Hi, everybody. It's Thursday at 5 o'clock, which means you are at the bar. I'm Inez Stepman with Independent Women's Forum.
And I'm Jennifer Braceras with Independent Women's Law Center.
And Jennifer and I just got back from our quarterly meeting, our IW quarterly meeting, which they take place in Washington, D.C. So we actually had a chance to have a drink in person for once together. But today we are back to our virtual happy hour, and I'm drinking red wine today.
And since this week marks the opening of the Supreme Court term, I'd like to raise a glass and toast to the Constitution and to all of its defenders, two of whom will be joining us today to discuss the year ahead. Hear, hear. I'd also, actually, if it's okay with you, Inez, like to take a brief moment to raise a glass to my father, Judge Jose Cabranes of the United States Court of Appeals of the Second Circuit, who announced yesterday his intention to take senior status at the age of 80, after more than 40 years on the bench, more than half of his life. He spent 15 of those years on the trial court, nominated by President Jimmy Carter, and the rest on the appointment of President Bill Clinton. I never thought this day would come, to be honest with you. I thought he would keep going and not take senior status forever. But he's been doing it a long time, and I think he just needs a break. People, last night when the news broke, a lot of people were chiming in on Twitter and texting me and talking about whether my father is a liberal or conservative, to which I can only say he defies categorization. He was appointed by Democrats, but he gave up his membership in any political party shortly after taking the bench. And he was often mentioned for the Supreme Court as a potential Democratic nominee whom Republicans would accept. So if truth be told, I will say that my dad is what a judge should be: impartial, nonpartisan, open-minded, hard to categorize, and a great defender of the American Constitution and our system of government. Congratulations.
Congratulations, and looks like he spawned a love in the law, a love of the law for his daughter as well. So that's a nice family tradition, particularly when it coincides with such a love of the Constitution and of the liberties and the systems that make the American way of life possible, and that so often I think this is not a new observation, but are so underappreciated by folks today who don't seem to realize how precious those liberties really are and how rare in human history. And that takes impartial judges to enforce that document. So
I'm only sad that his replacement by President Biden will no doubt be somebody who is not as impartial as he is. And so as a conservative, that I'm not pleased with that, but these decisions are highly personal, and you have to do it when the time is right and when you're ready. So it is what it is.
Well, maybe it's a commentary on where the Democratic Party, how the Democratic Party has changed even since Jimmy Carter and Bill Clinton. But on Monday, the Supreme Court, to turn to the subject of this at the bar, the Supreme Court opened the new term with in-person oral arguments. So the first time that the court has heard from lawyers in person since this entire pandemic started. They have been hearing these arguments via telephone, actually, not via Zoom. I think probably to try to preserve the idea that they aren't going to live stream video of these arguments, because once if they had done that for this coronavirus period, I feel like it would have been, people would have clamored for it to continue. I don't know, that's speculation, but I think that's probably why they did it. But for now, they are returning to in-person oral arguments, and this is the first time that Justice Amy Coney Barrett has been participating in in-person arguments.
And now that they're back in the courtroom, we can be protected from once again hearing the flush heard around the world. I'm still wondering who that was, but we can get into that later. One Justice Brett Kavanaugh participated remotely after testing positive for COVID last week. And interestingly, Justice Sonia Sotomayor wore a black face mask while the court's other justices were maskless. No members of the public were allowed in.
I bet they'd like to actually keep that last part going. No video and no members of the public. But we have a fantastic pair of guests to discuss some of the most important cases that are coming up in this next term. So Anastasia Bowden is an attorney with the Pacific Legal Foundation, where she leads the Economic Liberty Practice Group. She's a graduate of Georgetown Law. She's litigated cases concerning sex discrimination under the Equal Protection Clause and freedom of speech under the First Amendment. She's also the co-host of the DIST podcast, which tells the stories behind historic dissenting opinions, which is such a cool idea. You should really check that out. And you can follow her on Twitter at Anastasia_Esquire. And in the interest of full disclosure, we should note two things. One, that I used to clerk for Anastasia way back in the day when I was a baby law student. And that was at PLF. And then also that IW filed a friend of the court brief in the Ninth Circuit in support of one of Anastasia's clients, who is challenging the California requirement that corporations adopt female quotas for their boards of directors, which is a very interesting case in itself. But we are talking SCOTUS cases these days, today anyway. So welcome, Anastasia, to At the Bar.
Thanks for having me.
Hey there. Thanks for being here.
One day that woman quota case will be a Supreme Court case, Inez. You just wait.
Oh, good.
And we'll have you back on to talk about it.
Yeah, definitely. Our second guest today, Willy Jay, leads the Supreme Court and appellate litigation practice at Goodwin Procter, where, also in the interest of full disclosure, I should say he is one of my husband's law partners. Willy is a graduate of Harvard Law School, a former assistant to the Solicitor General, and a former clerk to the late Justice Antonin Scalia. He has argued 17 cases before the High Court and submitted briefs in more than 200, one of which he filed on behalf of the Independent Women's Law Center last year in an important free speech case. Welcome, Willy.
Great to be here. Good to see you.
Thanks. So, as Inez said, the Supreme Court opened on Monday. And I'm wondering if you can tell us generally, or tell our non-legal viewers generally, just quickly how the Supreme Court decides which cases it's going to hear, and then maybe give your first impressions of the term, what you know about it so far. Actually, well, go ahead. Yeah, you go ahead.
Well, actually, let me jump in right here. We have kind of a fun little clip to kick off this discussion. So we'll show this little clip first, and then we'll continue, Willy, with the question that Jennifer asked.
And lawyers, guns, and money. Get me out of this hell. I'm the innocent bystander. Somehow I got stuck between the rock and a hard place. And I'm down on my luck. Yes, I'm down on my luck. But I'm down on my luck. And I'm hiding in Honduras. I'm a desperate man. Send lawyers, guns, and money. The shares hit the fan. Hey!
The reason we play that is because the subjects are going to be lawyers, guns, and money, as well as school choice. But Willy, why don't you give us your impression, as Jennifer said, of why you think the court chose this particular bunch of cases for this term?
Well, obviously the court can only take the cases that people bring there. And so some of these issues have been percolating for a long time, but haven't made it up from the state courts and the federal appeals courts to the Supreme Court. And then others have been basically lines of cases that have been developing for a while. Like we're going to talk about the school funding case out of Maine. And the reason that case is here is because of a case the court heard from a couple of years ago from Montana. The reason that case is here is from a case about playgrounds from Missouri from a few years before that. That the direction that those who advocate for increased scrutiny of state laws that prohibit religious schools from getting access to money, they've been moving in this direction toward a case like this one from Maine. So some of it is long-term strategy that's been years in the making. But the very simple answer to your question is the Supreme Court will hear any case that 4 out of the 9 justices want to hear. And you might be surprised which justices choose to hear which cases. It doesn't always track with how they wind up voting on the merits. And in particular, some justices who you might think would be very much on the side of the petitioner in a particular case will choose not to hear that case if they think they're going to lose. So the Second Amendment case that the court is going to hear this term, when the court's membership was a little bit different, the court declined a whole bunch of Second Amendment petitions all at one go. And the thinking around that was that the justices more sympathetic to Second Amendment rights thought that they couldn't get a majority. And so we're not going to push to take any new cases. So each of these issues, I think we're going to work through over the course of this time at the bar. But a lot of strategy goes into litigants bringing cases to the court and the justices choosing which ones to hear.
I'm glad you wrapped up with the guns aspect of this. So, Anastasia, can you tell us a little bit about the Second Amendment case that is on the docket, which, as Willy said, the court had turned down a bunch of Second Amendment cases, perhaps because they feared they weren't the right vehicle or the composition of the court has changed with the addition of Justice Barrett. But they have taken, finally, a Second Amendment case this round. So can you tell us a little bit about that case?
Yeah, I think this case really is interesting, not just for the facts or sort of the precedent at stake, but exactly for the reason Willy and you both point out, which is sort of the incremental way that the court works and the way that the law develops, because it was, I guess over a decade now where the court first recognized an individual right to bear arms. That was untethered to your participation in the militia, and recognized that right was incorporated against the states in the cases of McDonald and Heller. And since then, the court hasn't really filled out what that right means. It said that you do have that right, but we don't know. Of course, with any right, there's some extent to which the government can burden the right. Most rights are not considered absolute by the Supreme Court. And so now we're going to fill that out a little bit. And the court had taken up a case last year out of New York because New York had prevented people from taking even licensed firearms outside of the city. Even if you were just going to your vacation home, New York City had prevented that. And so the court had taken that up, and ultimately the state mooted its own lawsuit, and the Supreme Court ended up dismissing that case from its docket, with a couple of justices saying, even though it had been dismissed, we still should really take up this issue. We should have heard it. This is really important, or we're going to hear it again. And here we are the next term. It's a different law at issue where in order to get a license to carry outside of the home, you have to prove that there's a really, really good reason for it, that you need it for self-defense. And a couple of people who had been denied such a license brought suit. And now we will find out if burdening your Second Amendment right to bear arms outside of the home violates the Second Amendment.
So just to clarify for our non-legal audience, when you say that the New York mooted the case, you mean that they repealed the law in question, right?
Yeah, that's right. I throw that term out because I see it so frequently in my litigation. Very often, we bring a lawsuit. I only sue the government. I work at a public interest organization that's devoted to constitutional lawsuits. And we see this all the time, that, just as there's a strategy that goes on part of the plaintiffs, there's certainly strategy that goes on behalf of the government. And we'll find that, very often if they think that they're going to get a bad outcome, or even worse, they're going to set bad precedent, they will they'll repeal their law. And so that's what happened here.
And the law that is being challenged currently differs from the city's law that was repealed. How?
Yes, in the case that was accepted last term, the law prohibited anybody from leaving the city with their concealed weapon, whereas here you have to get a license to carry. So it's nearly the same, just different in scope, I suppose.
This is a case I have a personal stake in somewhat, as I don't have a firearm now, but I have considered buying, and I live in New York City. It is really complicated, and there have been not just a concealed carry, which is at issue in this case, but generally to even to go through the permitting process to even own a firearm at home is very, very difficult here. Although I came from DC, where it's even worse. So, I mean, is this the beginning of a court that might actually enforce the principles of Heller and the incorporation of the Second Amendment? Because, as you say, we had these landmark cases, and that seemed to be very strong for the Second Amendment, for the right to own a firearm. And then we didn't really see a lot of states changing their restrictive gun control laws because, as you say, it wasn't at all clear how that right would be enforced by the courts. And this is really the first foray they're going to go into what it means and what kinds of regulations about firearm ownership are permissible or not. Like, what do you expect the court to do in this case?
Yeah, I think it's interesting because even though someone like Justice Kagan has even said we're all originalists now, some justices are more originalist than others, shall we say. And so the more originalist that we get, the closer that we stay to the original intention and the original public meaning of the founders when it wrote the Constitution. I think that naturally lends itself to more liberty because the Constitution is a very liberty-oriented document, and it actually takes rewriting the Constitution or undermining its provisions in order to get more government restriction. So now that we have justices who are avowedly more originalists, I do think that we will get a more serious engagement with these laws, some better scrutiny of these laws, and ultimately that translates into decisions that are better for policy. And that's not to say that these judges are, a partisan or outcome oriented. They're applying a judicial philosophy that is rooted in its own principles, and that tends to result in decisions that favor liberty.
So that's actually a good segue, because I was going to ask Willy how you would explain to, again, a non-lawyer, sort of the about face that Heller represented. Is it just, as I think the press would say, judges behaving politically, or is it, as Anastasia says, just a reinvigorated commitment to originalism? And how would you explain that shift to somebody who doesn't follow these things closely?
Yeah, I think that the fairest way to describe Heller was that the court had not actually answered this question directly in any case, and really even the dissenters, I think, agreed with that. They didn't say this is a closed case and how dare you overturn our prior precedent. Justice Stevens's dissent went back to the original public meaning of the Second Amendment as well, came to a very different conclusion on it. And Justice Stevens, I think, has forthrightly said in retirement that if he could get rid of just a few decisions of the Supreme Court, Heller would be one of them. But while during that time that the Supreme Court was quiet on the subject, I think that a lot of activists in this area had allowed themselves to believe and had kind of made part of their messaging that the Second Amendment doesn't really have anything to say about the ability to ban firearms or who can carry them. And
their argument is always it applies only to militias.
Right, exactly. They would stop reading after the first few words of the amendment being a well-regulated militia and not get to the part about the right to keep and bear arms.
And they claim, I mean, pretty explicitly, I would say the anti-Second Amendment crowd claim pretty explicitly that up until Heller, the Supreme Court had only ever held that it applied to militias, when in fact, what you're saying is they never really had a chance to address whether it applied beyond that. I
think that that's right. I mean, there was this one cryptic precedent from the 1930s that I think a lot more hay had been made from than in the kind of the minds of legislators and activists and people involved in the gun control debate for many years than it actually occupied in Heller itself.
One, this is a lesson in the importance of precision in legal writing, right? Because a lot of this hinges on a comma. These two radically different views of the Second Amendment depends on how you read the clauses of the Second Amendment. Of course, I agree with originalists that this is sophistry, and that if you actually it clearly at the time had a certain public meaning, as Anastasia said. But it's funny how much can hinge in legal writing on a comma, even in a document that is so sort of not legalese written as the Constitution, that is meant to be read by everyone, by all of its citizens, not just those with like a legal background or legislative background. But it is kind of a funny argument, because to get like to the specifics of the law here, essentially what New York is saying is that in order to exercise your Second Amendment right, you have to prove that you are somehow different from the rest of the population, that you have some special need to defend yourself, which seems like a really odd way to talk about a constitutional right in a more fundamental way, right? Like, it's a very strange thing to say, well, you have this constitutional right, but you can't exercise it unless you prove yourself essentially unique from the rest of the people who presumably also have that constitutional right. I mean, could you address or maybe explain the argument from the other side a little better for me? Because that seemed to me to be just like from a total layman's perspective or from a logical perspective, that seemed like a very strange way to talk or write about a constitutional right.
Yeah.
I'll take a stab at it, or Anastasia, you want to go first?
Either way. By all means, Willy.
Willy, go first, and then we'll bring on. Sorry, that was my fault as a moderator. I didn't indicate. Willy, if you could answer first, and then we'll bring in Anastasia.
I mean, I think that the defenders are basically saying that the right stops at the property line, pretty much. That the right of armed self-defense is to defend yourself in your home, and that the constitutional right, as a matter of history or original public meaning or something, stops outside the home and the boundaries of the home. So that's the strongest form of their argument. And then they have a backup argument that says, well, constitutional rights can always be limited reasonably, and that our restriction is reasonable. But they really would, and the Second Circuit, the strongest form of the Second Circuit's reasoning in upholding this law was exactly that the right stops at your property line, pretty much.
Yeah, I was just going to add to that it's trying to cabin the Second Amendment right in the same way that people who were seeking to limit the Second Amendment said that right was only limited to the militia. So at first it was, it's only tethered to the militia. And then after we said that's not true, it was, now it's only tethered to the household. And then now they're saying, well, now it's only tethered to if you have a special need. And I think this is not something unique to the Second Amendment. It's something we see in the context of plenty of amendments. If you think about the First Amendment and the right to free speech, we see people who favor government regulation or maybe favor democracy over individual liberty. They say, sure, you have a right to political speech, but commercial speech, that's a little bit different, even though that distinction is found nowhere in the First Amendment. Or if you think about the Equal Protection Clause, they say, well, if it has to do with race, then you get strict scrutiny, but if it has to do with sex, then it's intermediate scrutiny. If it has to do with whatever, then it's relegated to rational basis. So we see this sort of a creation of tiers of scrutiny or cabining rights in certain ways with all sorts of amendments, even though the amendments of themselves are pretty absolute.
So one thing we tried to do, IWF and the Law Center filed a brief in this case. And one thing we tried to do was sort of show the absurdity of the argument that you need to show a special need by pointing out that women benefit from gun ownership and the right to defend themselves, and that they do have this special need. But of course, women are the majority of the population. So if the majority of the population has a special need for self-defense, conceivably, even higher numbers have that need. So we'll see what they do with that.
Yeah, let's turn to the next case on our docket that we're discussing today, which is one it's definitely close to my heart, given that most of my background is working in school choice and in education reform. So this is a follow-up essentially to the Espinoza case, as Willy, I think, mentioned initially. and that's Carson v. Macon. And this is about a Maine program that, if as far as school choice programs go, is nearly unique. There's one other like this in the nation, in the sense that it actually goes back way before the modern school choice movement. So when we think about school choice programs that allow parents to take some portion of state funds and use it for a school of their choice, or in some cases to sort of piecemeal assemble an education for their children from a variety of providers. But if we think about those kind of modern programs, those really started in the 1990s. But Maine's program goes back much further than that. It's over a century old, and it's essentially designed to solve the problem of very rural school districts, right? Where you might have a town that is so rural and has such a low population that it doesn't actually make sense for the town to support, for example, a high school. And so what Maine has been doing for a very long time is called the tuitioning program, where they give families money to then access, if in that town or closer there is some form of private education. There's no way for that very rural town to support both this private institution that exists as well as a second public high school. And so what they allow is folks from these rural towns, if your geographic location qualifies, to essentially take those dollars anywhere they like. In fact, they allow people to take it out of state as well. But what they have disallowed people to use those funds for are religious or sectarian, which will be an important distinction at some point, but sectarian schools, meaning essentially religious private schools. So Anastasia, can you talk us through the contours of this case, and then again, what you expect the court to do with it?
Yeah, I think this case, once again, is such an interesting study in incrementalism, beginning with the Zellman case, where the Supreme Court said that if a state gives out vouchers and chooses to allow school vouchers to sectarian schools, does that violate the Establishment Clause? And the Supreme Court said no, because it's not as if the government is giving money directly to the schools. It's being essentially channeled through the choices of the students and the parents themselves. It's a function of their choice. And in that way, it's not a violation of the First Amendment. So that really built out what the state could do, but it did not answer what it must do. And so since then, there have been a few other cases, including the case that was referenced earlier, Espinoza, from I think it was the 2019 term, which said that if a state chooses to, essentially, if it chooses to give out tax credits to schools, can it disallow those tax credits to sectarian schools, which essentially means must it, if it gives out money to these non-sectarian schools, but it also allow them to the sectarian schools? And the Supreme Court said yes, but that was because the court was disallowing the money to go to these sectarian schools solely on the basis of them being sectarian. Now, this goes a little bit further, the case this term out of Maine, which asks whether the government can discriminate on the basis of the school actually having a sectarian curriculum. So again, it's just these incremental steps to further the liberty at issue. In terms of what will happen, I mean, it's always a gamble when you're betting on the Supreme Court, because the Supreme Court and the justices are lawyers doing law, because it's not partisan, because law is complex and nuanced, and because you get interesting arrangements and alignments, and it's just very hard to predict. But if I had to predict, I do think that at the end of the day, the Supreme Court is going to say that you can't even disallow any sort of aid to schools on the basis of their curriculum, and for the very same reasons that it ruled the same way in the Espinoza case and Zellman. These things are a function of student choice, parent choice, and to disallow it is essentially some form of discrimination. But I'm not a betting woman, and one shouldn't be when it comes to the Supreme Court.
I want to drill down a little bit on that distinction between status and curriculum, because I mean, it's so interesting to me. I think anybody who is even remotely religious, or who's ever sent their child to a religious school, even if they're not religious, understands that status and mission, if you will, are one and the same. And it's really splitting hairs to say, I mean, the court's already said you can't discriminate against schools because they're religious schools. But what does it mean to be a religious school? Well, of course it means you're imparting the faith. Now, maybe you don't teach, the catechism of the Catholic Church, but you're teaching it through, I guess, your school rules, your school morals, ethics classes, other things. I mean, it is virtually, I think, impossible to separate the two. What would you say to that, Willy?
Yeah, I mean, if you're only protected against discrimination based on your status, I mean, that means that the Catholics can run a secular private school just like a secular group can run a secular private school. But we are, after all, talking about a provision of the Constitution that protects the free exercise of religion, right? It's not just that religious people, right? It's not just that religious people get the same right to go to the grocery store, run a school, and get the mail as everybody else. It has to do with the free exercise of religion. That includes ministering to congregations. It includes worshiping according to religious doctrine. And for many denominations, though certainly not all, it means bringing up their children in the faith.
Yeah, it does seem like a part of this sort of strain, not only in the law but in the broader culture, to try to cabin religion as only something that can happen within four walls of a church, for example, and the idea that you could have a Catholic school that doesn't in any way live out the Catholic doctrine or the Catholic faith and still call it, that the Catholic school has the right not to be discriminated against if they don't act like Catholics. That seems to me, again, to be such a limiting and a hollow way to think about religious liberty. What do you think, Anastasia?
Yeah, I mean, I would have to agree, and just not really on a legal point, but just an interesting policy point about why this case is so salient. I think school choice has really become increasingly important in the era of COVID, when people became acutely aware of what it means to be limited in your school choice, and to have to be shut out from public schools, and particularly how it affects people who can't afford to go to private schools. And so people are favoring this. And in fact, I just think it's interesting that in my own life, I've seen friends who are not religious choosing to go to sectarian schools exactly because they offer more choice, because they had different protocol, because they're teaching different curricula. So it's just an interesting thing about, regardless of the curricula, more and more people are choosing to go to these schools, and how important choice really is right now and salient to people.
And I think another thing, I mean, this isn't a legal point, but it goes to what you're talking about in terms of choice and why people are pulling their kids out of some public schools and choosing sectarian schools now. Because the truth is that non-denominational, non-religious schools often have a very real religion of their own. It might not be Judaism or Christianity or any of the major religions, but they are essentially proselytizing a faith, an ideological faith, right? We've seen that with critical race theory. We've seen it with, environmental justice in some schools. And they are teaching it as a dogma, not as a method of inquiry. And so, to some extent, all schools are religious schools, if you think about it that way.
Yeah, actually, I'd like you guys to address something that may be a little bit in the weeds, but to the point that Jennifer just made. Why is there such a big split in how we think about the two clauses that relate to religion in the First Amendment, right? Because when we think of free exercise, versus establishment, right, that you shall not, Congress shall make no laws respecting the establishment of religion. On the other hand, free exercise, right? It seems like for the latter, for free exercise, we have this very expansive definition of what counts as religion, right? Here I'm thinking about the cases from the 1960s and 70s where you had conscientious objectors who didn't want to go to the Vietnam War, and were essentially claiming something akin to secular humanism as a religion, and the court declining, just understandably so, right? Declining to really kind of dig too far into what is and isn't a religion. But then on the flip side, to the point Jennifer just made, on the establishment side, even when you have an ideology that seems to have a lot in common with a faith, in the sense that it has a doctrine and that it enforces a code of ethics, and is certainly a deeply held belief, right, with regard to its practitioners. And I'm being intentionally sort of provocative here, but is that something you see the court resolving at any point? This sort of, on the one piece of the First Amendment and the religious liberty parts of that amendment, we have this very expansive definition that includes your view on life, the universe, and everything. And on the other hand, on the establishment side, there's no case that I'm aware, and I don't think there would ever be, like, in the foreseeable future, on basis to bring a establishment case against what seems like an ideological religion that's being taught in public schools.
I think people have occasionally brought claims against local schools that were teaching, for example, a version of environmentalism that goes so far as to worship Gaia, it's like the personification of the earth. And there's been some small amount of litigation like that. But I think at the Supreme Court level, religion on the free exercise side has actually been something that more often has united rather than divided the justices. In the Obama administration, which never called it free exercise, it only called it freedom of worship, took the remarkable position that federal law could regulate churches' selections of ministers and religion teachers under anti-discrimination law. And the justices were unanimous in saying that is a remarkable position and we reject it. So while establishment questions have definitely split the justices along ideological lines for many, 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 many years, and the school voucher case from the early 2000s, Zellman was one such case, free exercise has actually caused the court to cross ideological lines more often than it has divided kind of Republican appointees versus Democratic appointees.
So we've talked about lawyers and guns and school choice. Now I'd like to move on to money.
Sorry, that was my fault. I put it out of order from the song, but
oh no, that is
responsibility for switching money out of its rightful place. Rhetorically,
no, it's fine. Yeah. So the next case we're going to talk about is called CVS versus Doe, and I think for non-lawyers, this case seems a little complicated, in the weeds, and not that important. But when you really look at it and take a bird's eye view of this case, there are a lot of things that can impact regular people on a daily basis in this case. Basically, what you have is plaintiff's lawyers trying to get money from CVS Pharmacy for a policy that they say has a disproportionate negative impact on a subset of disabled people, in this case, people with HIV. But the implications go far beyond HIV, far beyond pharmacies, far beyond healthcare. So, Willy, could you tell us a little bit about that case and why this whole notion of disparate impact theory matters to public policy generally and to the average person?
Right. Disparate impact is a theory of discrimination that doesn't involve anyone actually intentionally discriminating. I mean, it is the theory that even a series of choices that don't involve intentionally treating people of one race better than another, one sex, one religion, people with or without disabilities better than others, that designing, whether it's a public policy or a service that banks offer, or in this case, a pharmaceutical benefit in a health insurance system, that the way that it results winds up being unequal and burdening people with a protected characteristic, and that it therefore is illegal. That's what disparate impact is, and this is something that's come up in the race context. An employment practice that winds up screening out more minorities than white applicants, or
Right,
in the
so in the race context, the classic example that you'd hear is that a certain test has a discriminatory impact, let's say, on a certain racial or ethnic group. So people will argue, the SAT has a discriminatory impact on Blacks and Hispanics, or they might say, they might argue that a physical fitness test has a disparate negative impact on women who are applying to the police academy. That's the type of litigation that you might typically see in this area. But disability is fundamentally different than either race and sex. And I'm not a big fan of disparate impact in those contexts either. But taking it into the disability context seems so extreme to me, particularly because the disabled community isn't a monolith. So you could potentially have a policy that has a negative impact, for example, on the blind, but a positive impact on the deaf, right? And so why should courts be in the business of deciding which group policy favors? That's sort of my big, bird's eye view and problem with this line of cases.
And what the court's being asked to decide is that basically federal money, as I think most of the viewers probably know, comes with a lot of strings. When you take money from the federal government, you are agreeing to a bunch of conditions that have been written by some of them by Congress, some of them by administrative agencies. And the question is one of those strings, we know that one of those strings is you can't discriminate against disabled people in a federally funded program. But does that extend so far as the kind of prohibition on disparate impact that employers face, or banks doing fair lending face? And so the facts of this case are kind of interesting because the plaintiffs belong to a health plan, and the health plan pays for the pharmaceuticals that they use to treat their HIV. As Jennifer mentioned, it's a class of HIV positive plaintiffs. And CVS, which is the benefits administrator, says, I think basically for cost reasons, medicines in these categories, and that includes but is not limited to these HIV medications, you've got to get through the mail order pharmacy. Why? Because it's cheaper, and because you take them for a much longer period of time, you're getting a larger supply, and so on. And they're saying that the right to go to the pharmacy and to see the pharmacist and to get your prescription filled in person, that is what they're seeking access to. And they're saying that this has a disproportionate impact on disabled people, even though it clearly was not designed to discriminate against disabled people.
Well, and in fact, it's even more silly than that, because first of all, the whole idea of mail order prescriptions was designed to aid the disabled who might have trouble getting to the pharmacy. So that's
right.
One
if you're in a wheelchair, you might well like mail order quite a bit.
But the other piece of it is that they don't require you to get it only by mail order. You can go and get it at CVS. If you prefer to go and talk to the pharmacist, you can get it from their pharmacy. And it's the absurdity of this case is that they're saying, well, we don't want to get it by mail order, and we don't want to go to CVS because CVS pharmacists are indiscreet, or they don't give good advice about how to take the medicine and when. We want to go to our local pharmacy. And the fact that you won't let us go to, the ABC pharmacy of East whatever, discriminates against us because we have HIV. I mean, I don't know how the justices don't just laugh this out of court.
So a lot of contingencies have to be true for this plaintiff class to actually win. But the way the court has taken it is it really is just asking the first and biggest question: is disparate impact a thing in disability law at all in the federal funding context? And also, there are different statutes that apply to health plans that take federal money, including any plan that you get on the Obamacare exchanges, Medicaid, anything with federal money attached. So if you're a university, you obviously get federal money in the form of Pell Grants and research funding. And those strings that you get with federal money, they extend all throughout your program. if you're a university, for example. So this is the idea that you have to relook at every choice you've made and every way you've structured your operations to see if they have a disparate impact on the basis of disability, not just disability generally, but as Jennifer said a few minutes ago, like every conceivable disability. You can see why this is a case that the business community, the higher ed community, and basically anyone in the in a business that involves taking federal money is concerned about.
It really puts businesses and educators between a rock and a hard place. One of the examples we pointed out in our brief in this case is, example with respect to the mask mandate, because the Biden administration has recently said that they're going to investigate schools that prohibit masks, because that could be a violation of could have a disparate impact on disabled students who, might have some underlying condition and puts them at risk of the virus. Well, you could equally argue that students with certain learning disabilities are disparately impacted by having to wear a mask because they can't see social cues, they can't see their teacher's lips moving when they speak. And so children with certain learning issues are negatively impacted by that. So once again, you have two groups of disabled students who are impacted exactly oppositely by a policy. And the question is, should the courts decide that, or should politicians who are close to the people decide that? I mean, clearly, in my view, it's not the courts that should be making those types of decisions.
Yeah, I think it's interesting that in the context of this case, it really is more about money. But as you said, disparate impact comes up in a lot of different contexts. And more traditionally, it comes up with discrimination with regards to immutable characteristics. And I think thematically, what's going on in these cases is blurring the line of what constitutes discrimination. All these cases are coming up in the context of discrimination. Well, discrimination is about differential treatment on the basis of a characteristic. And it's about intent as well. That's what discrimination is, right? It's treating somebody differently with the intent to discriminate. You're treating them differently and on the basis of that characteristic. And disparate impact elides those two things. It looks at people solely, it looks at policies solely in terms of their effect on different groups. And to me, that's a different question. And also it's really counter to the promise of equal protection and getting rid of discrimination, which is making sure that individuals are protected from invidious treatment. And, ultimately what it ends up doing is it leads people, when they just focus solely on the impact on groups, it leads to balance. It leads to balancing to avoid that disparate impact. And so it actually leads to, in the racial context, you can see this with employer policies, is they are so terrified of producing a disparate impact, even if the policy itself is not discriminatory and it's not intended to discriminate, but it might have a disparate impact, that they will sort of engineer things in ways to create a racial balance. So it's actually perpetuating discrimination in the process. And that's why I think a lot of this focus on groups is wrong. The value of a policy doesn't come from how it affects groups. The value in a policy comes from the value of the policy. Is it arbitrary or not? Is it good or not? Some policies which cause disparate impacts might be fine in and of themselves. You can imagine, what if a law against murder happened to affect people with blonde hair? That doesn't mean that now we have to throw out the policy against murder.
Right.
The value of the policy
criminal laws have a disparate impact on men.
Right.
Right.
Exactly.
Laws, right? We're supposed to throw those all out.
Fundamentally, every single that's my dog. Every single policy in some way, I really can't think of a policy that doesn't have disparate impact, where, as you say, if you work backwards from the assumption that people are equal as groups rather than equal as individuals, virtually any law passed in the United States or any other civilization, frankly, if you work backwards from groups, is going to have disparate impact for a variety of reasons. And we could have an entire, at the bar discussing all of the reasons that there might be a disparate impact. But that's why I find this analysis so pernicious. As Jennifer has said, it's particularly ridiculous when you're talking about the disabled, because you could have different kinds of disabilities that are impacted in totally opposite ways. But even this kind of analysis for race and for sex ignores all of those other factors that go into, how an individual navigates both life and then under the law, and really reduces them only to these group characteristics, a member of a pod or a group, right? And then if the group is not doing exactly the same as this other group, then the assumption is that the underlying reason must be discrimination, when in fact there could be many, many other reasons. Where is disparate impact analysis most used under the law? And I'm going to ask Anastasia here, where do you see it becoming more popular, if you see it becoming more popular in the courts? And, where should we be looking at? What should we be looking at in this case for the Supreme Court, perhaps to set the tone, not just in the narrow case, or perhaps they'll do that as well, but is there the possibility that the court will set the tone on this kind of disparate impact analysis question beyond the boundaries of IDEA or disability law?
Yeah, I'm not sure if we'll get anything like that out of this case, just because from my perspective and from what I've heard from others is that this case is so open shut. It's the text of the statute itself that it prohibits discrimination solely by reason of disability. And that is very clear that it's not meant to encompass disparate impact. It's meant to encompass intentional discrimination on the basis of disability, compared to other statutes which contain other flowery language, which talks about how any policy that affects groups will also be illegal. So just because this case is so open shut, and in fact, there was a 4-1 circuit split with only one circuit, I believe, on that side, although in any event, I don't know that we'll get it from this case, but I do, again, think thematically what's happening here, and we do see this most often in the context of race, is this hyper focus on group. And that's just so fascinating to me, that you're elevating group characteristics, the very characteristics that are supposed to be arbitrary, the characteristics that we have no control over and we're born into, like our sex, like our race. You make that the most important thing in analyzing people and policies, and to me, and on the basis of groups too. And that just gets exactly the idea of individualism and the idea of equal protection before the law wrong. And so it is a sort of pernicious thing.
I just want to point out, though, that disparate impact or disproportionate impact, as a theory itself, I think is not useful, but as evidence, it can be. And so, in other words, it's not always irrelevant. And so when you're trying to prove an intentional discrimination case, a jury, for example, would look at the totality of the circumstances. Were there negative comments made about this person on the basis of his or her race? And did the people who make those negative comments, racial comments, say, implement policies that then had a negative impact on those groups? That would be relevant. So, for example, in a college admissions policy case, for example, just to name a hypothetical, to raise a hypothetical, if you had people saying negative things about Asians in a college admissions office, and then those people went and implemented a policy that said nobody with certain personality traits or certain resume characteristics could get into that school, and that policy then had a disparate impact on Asians, that might be one piece of evidence to show discrimination. But the policy in and of itself proves nothing, in my opinion.
I'm totally with you on that it can be used as evidence, but it shouldn't be determinative. And unfortunately, I think, just not to bring it back to the woman quota, but just briefly, at this point, I feel like very often any disparity between groups, the government is now seeking to remedy as an end in and of itself, regardless of if that disparity is a result of discrimination. And that's the real problem. We can't seek balance on group basis for its own sake. You can use it as evidence of intentional discrimination, but it shouldn't be determinative.
Well, we have time to just barely touch on one last case here, and that is a death penalty case. about the unfortunate bombing that happened at the Boston Marathon. So if you rewind your memory a little bit, there were of course extremely tragic consequences. A pair of brothers bombed, I believe, the finish line of the Boston Marathon. And now one of those cases, the death penalty case, is being accepted by the Supreme Court for review. So Willy, could you give us just a brief overview of that case and what you expect?
Sure. I mean, just very briefly, the appeals court in Boston threw out the death sentence because they said that the trial judge had not done a good enough job screening the jury for exposure to pretrial publicity. They could even have thrown out the conviction if it hadn't been clear that from his own admission that he was guilty. So they said harmless error as to the conviction, but they threw out the death sentence. They also said that he should have been able to argue, basically, to put in more evidence, even though unreliable, of his brother's past criminal history to show that it was really more his brother who was the bad guy and that he deserved a life sentence rather than death. So the government took this case to the Supreme Court. The petition was filed under the Trump administration. The Supreme Court, interestingly, held on to the petition for several weeks after the inauguration, I think waiting to see if the Biden administration would pull the petition and basically give up on the death sentence, or at least agree to a retrial instead. And it didn't do that. The administration is continuing to defend the death sentence, even while there is an execution moratorium, because, quite frankly, this defendant is the worst possible defendant on which to draw a line in the sand and say we're against the federal death penalty if you're the administration. So the two questions that the court's going to hear next week are basically, how much deference does the trial judge get in picking a jury in a high-profile case, and how much leeway does a capital defendant get in putting in evidence of mitigation, reasons why he shouldn't get the death penalty?
Anastasia, do you have anything to add about this case? It's fine if you don't.
Totally outside of my practice, so I'm gonna leave it at that.
All right. Well, we are going to wrap up if that's the case. This has been another episode of At the Bar, which we do every Thursday at 5:00. We usually have our wine or our drinks, and we have great guests like these two. Willy, Anastasia, thank you so much for joining us here today at the bar and giving us a little preview of the upcoming Supreme Court term. We'll be looking for these cases and more when those decisions are handed down. Jennifer, you have anything to wrap up with here?
Yeah, I just want to remind people that At the Bar is a production of Independent Women's Forum, and it is available for viewing on Facebook, YouTube, and IWF.org. It's also available for download on all your favorite podcast apps: iTunes, Spotify, SoundCloud, TuneIn, Stitcher, Google Play, iHeartRadio, and others. So download it, listen to it in the car, listen to past episodes, and we hope you'll join us again in 2 weeks at the bar.
Yes, please join us in 2 weeks. Sorry, I correct myself. It's every 2 weeks, not every 1 week. But yes, every 2 weeks at the bar is on Thursday, 5:00. Come join us. We hope you'll join us again in the next 2 weeks, and we'll see you at the bar.